Good afternoon, Section Z. Continuing on in Chapter 11 on zoning, the next topic we take up is the non-conforming use. So the Village of Euclid case had to do with a zoning ordinance that was adopted that had an impact on some vacant and unused land, lots that weren't being used at the time the ordinance was enacted. But what happens if a city wants to adopt a zoning ordinance and some of the property is already being used in ways that are inconsistent with the new plan that the city wants to implement? This is the problem of the non-conforming use. So to take a concrete example, imagine that a city wants to establish a new residential district within the city limits. But in that area, there is a property that is already being used as a junkyard. Has been for 10 years, it's ongoing business. And so when they adopt their ordinance that creates this new residential district, including the land where the junkyard is located, the city is going to have to decide what do they do about non-conforming uses of property in an area that is being subjected to a new zoning classification. And so what are their options? What could they do? Well, one option for the city might be to just buy the junkyard, exercise the power of eminent domain, force the junkyard owner to sell the property, and then that would allow them to shut it down and to pay just compensation to the owner, and then make the land available for a conforming use that would work with their plan. But many cities might be financially strapped. They might not want to expend the money necessary to purchase property in those circumstances. And so city planners may be looking for other ways to deal with a non-conforming use. A second option is they could simply adopt their regulation and not purchase the property, but tell the owner of the non-conforming use that you have to quit now, that your use is no longer lawful, that it is a violation of your newly enacted ordinance. The problem there, as we will see more when we get into Chapter 12, is that there is a high risk, a likelihood that that is going to be deemed a regulatory taking of the property, that the city may be forced to buy the property and compensate the owner if they take that route, even though they are not purporting to exercise the power of eminent domain. They may be forced to in order to enforce their regulation. A third option that we see in the case that we'll be looking at in a minute is an amortization period. The city could adopt a new zoning ordinance or classification and tell non-conforming uses that they have a certain period of time in which they have to change to conform to the new rule, but they don't have to do it immediately. And so we'll look at a case on that in just a moment. A fourth option is they could permit non-conforming uses to continue. But of course, that kind of messes with the city's ability to accomplish whatever purposes it was trying to accomplish by adopting its new zoning classification. Sometimes you have seen city planners, the authors tell us, allowing continuation of non-conforming uses, but with regulations that are designed to try to eventually get them to conform or to close down. And so, for instance, there have been jurisdictions that say a non-conforming use can continue, but if that non-conforming use is discontinued or if it is abandoned, then it can't start back up again. Or you have seen jurisdictions that have done things like try to prevent maintenance or repair on buildings that are being used for a non-conforming use, in the hopes that eventually the business owner will stop the non-conforming use and come into conformity because the business is becoming more and more run down. So in the case that we're going to look at now, let me pull that up for us. PA Northwestern Distributors, Inc. versus Zoning Hearing Board. In this case, the owner of property was using it as an adult bookstore. At the time that he opened the business in Pennsylvania, This was a lawful location for an adult bookstore. Nothing prohibited that kind of a business at this place, and the owner had obtained the necessary permits and certificates. But very quickly after the adult bookstore opens, the city adopts a new zoning ordinance that goes into effect 24 days after the adult bookstore opened. And the adult bookstore does not conform to the new regulations. The reasons for this are down in footnote 1 on page 580. The ordinance says that adult commercial enterprises cannot operate within 500 feet of a school, or within 500 feet of a church, or within 1,000 feet of a residential area. And this adult bookstore violates all of those restrictions on location. So the ordinance says that if you do not conform to the new zoning ordinance, you don't have to stop immediately, but you have to stop within 90 days. You have an amortization period. You can spend 90 days closing down or coming into conformity with the ordinance, but you can't continue operating after 90 days. So the ordinance is challenged by the owner of the adult bookstore. The zoning hearing board and the lower courts had ruled in favor of the city, and they had done so based upon a decision in a case called Sullivan. And the Sullivan case, which is cited here at the bottom of 580, had decided that an amortization period is permissible. You can allow provisions that provide for amortization of non-conforming uses as long as the amortization period is reasonable, and the lower courts had decided that the amortization period of 90 days was reasonable here. They did so by adopting a definition of reasonableness that looked at the beneficial effects to the community of discontinuing the use and weighed those with the losses to the affected landowner. And on that standard, the court had decided that amortization provisions were reasonable. The lower courts had decided that this amortization provision was reasonable. And on appeal to the Pennsylvania Supreme Court, the court says that if that's the standard, it doesn't think the lower courts committed an error of law or an abuse of discretion. But the Pennsylvania Supreme Court rejects the outcome in the lower courts and refuses to follow the Sullivan decision. The court does that on the basis of this holding over on page 582. A lawful non-conforming use establishes in the property owner a vested property right which cannot be abrogated or destroyed unless it is a nuisance, it is abandoned, or it is extinguished by eminent domain. And so they just reject outright the idea of an amortization period if you have a lawful non-conforming use that isn't a nuisance. Now, in note 1 after the case, the authors are talking about a couple of hypotheticals to see if this rule makes sense. So the first hypothetical is a vacant piece of land that is worth $50,000. And then later, the city passes a zoning ordinance that has the effect of reducing the land's value by 3/4. So it was worth $50,000 before, it's worth $12,500 after the zoning ordinance. The author suggests that this is not likely to be deemed taking, not likely to be a constitutional problem. This is actually similar to the fact pattern in the Village of Euclid case, at least as accepted by the court, when they accepted the allegations that the zoning ordinance there reduced the value of the land by 2/3 or 3/4, depending on how you calculated it. So that's one hypothetical. The other hypothetical is that B purchases a vacant lot for $10,000 and then spends $40,000 putting a store on the premises. So it's been a $50,000 investment. And the store earns a 10% profit each year for 10 years. Then after 10 years, the city passes a zoning ordinance that requires only single-family dwellings. The value of B's land is reduced by 3/4. The ordinance requires B to discontinue the non-conforming use immediately. The authors tell us that the courts almost surely would declare it unconstitutional as a taking of B's property, or at least requiring just compensation in order to enforce the regulation. And so they kind of ask us to think about the relationship between the two hypotheticals. Is one of the landowners better off than the other? You know, apart from the issue of whether it's deemed a taking to regulate and whether compensation is required, which of the landowners would you rather be? Well, presumably, landowner B is in a better position than landowner A. The authors point out that, first of all, there's been a 10% net profit each year for 10 years, and so B may well have recovered the value of the initial investment in the lot and the store. Second, B may have an ongoing business that could be moved profitably to a different location. And so in many ways, B seems to be in a better position than A in the first hypothetical, and yet B is the one entitled to compensation under the takings clause, whereas A is not, according to the courts. And so is there a good reason for courts to protect the non-conforming use, the business that's actually been operating for 10 years, but not to protect the owner of the vacant lot, whose lot loses value as a result of an ordinance? And the authors speculate that, well, maybe one advantage of protecting the non-conforming use in the second hypothetical is that it gives people more protection or more incentives to invest in productive uses of the property. That maybe investments in property development would be less likely, they wouldn't be undertaken as readily if there was a risk that the city could just come in and rezone and make you stop the business that you are investing in. Note 2 on the page after the case asks, well, would it have mattered if there had been more than 90 days in the amortization period in the PA Northwestern case? The court's decision seems to make clear that it would not have made a difference in the reasoning of the Pennsylvania Supreme Court. They seem to just adopt a blanket rule against amortization periods at all, that you can't make somebody stop even if you give them a reasonable amortization period. But the authors think that it ought to make a difference, that if you had a longer amortization period that allowed more opportunity for the landowner to recover on their investment in the property, that should be significant in deciding whether the rezoning should be deemed to be a taking requiring compensation by the government. So, third question, or the third note after the case, has to do with the doctrine of vested rights. So if we say that non-conforming uses are protected against zoning authorities, that the non-conforming use can't simply be forced to stop immediately, then you have to decide which uses of property have become non-conforming uses. So what if a person is in the process of developing property for a particular use, and then a zoning classification change takes place that would make that anticipated use non-conforming? When does the landowner get protection under the doctrine of non-conforming use? And the authors indicate that that depends on the law in your particular jurisdiction as to when you are deemed to have vested rights in the non-conforming use. They say that the law on this varies from one jurisdiction to another, but that there are some variables that typically are going to be important in the analysis. What commitments have been made, what plans have been drawn, what permits have been obtained, what site preparations have been done, has construction been begun, You know, those sorts of questions are going to affect the analysis of whether the landowner has established vested rights in the non-conforming use subject to protection as a non-conforming use. So that's a good stopping point for this lecture. We'll go on next to talk about mechanisms to achieve more flexibility in the zoning process.